Welcome to the Professional Business Development, how commercial landlords and tenants are working through COVID shutdowns and reopenings. I'm Ashley Allwood, which you all know, the Director of Marketing for the Conroe Chamber, and we are glad that you are all able to join us today. Before we get started, I'll give you a friendly reminder to make sure that you guys all stay muted throughout the presentation today. And if you have any questions for our presenter, Mr. Bret Strong, please feel free to post them down in the chat below, and we'll make time to answer them at the end. So he has plenty of time to go through everything, see if he maybe already answers your question, but then we can answer them at the end. Now, without further ado, let me introduce our presenter today for PBD Online, Mr. Bret Strong. Founder and managing shareholder of the Strong Firm PC, Bret has been a resident and active community leader in the Woodlands, Texas for 30 years. Spent 11 years with the Shell Oil Company in areas of contracting, finance, information services prior to becoming licensed in the legal field and establishing his practice in the Woodlands in 1996. Also, he's a Yankee like me from Indiana, so that's pretty cool. He's been the recipient of many local awards and has served on many local nonprofit boards in our community. Thank you so much, Bret, for joining us today to share your expertise. I know we're going to learn a lot today. And now I'll switch over the hosting rights over to you so you can begin your presentation.
Thank you, Ashley. Appreciate that.
There you go, making the host.
There we go, and let me go ahead and screen share. Okay, can you all see my screen?
No.
Not yet? Okay, hold on then. Bear with me. All right, Ashley, what are we doing wrong here? Oh, here we go. How about now?
There we go.
Okay, perfect. Okay. Well, once again, thank you everybody for joining us. As Ashley mentioned, we're going to talk a little bit about how commercial landlords and tenants are working through COVID shutdowns and then reopening. Our practice, just so as a way of introduction here, has really been focused the last 3 or 4 months very heavily on this issue. As you can imagine, with restaurants, anyone in the entertainment business, anyone in the hospitality business, anyone who was shut down with significant numbers had to figure out how it was they were going to survive and stay alive. In most cases, you have commercial tenants where you have someone who owns a building, someone who's leasing that building, someone maybe who's lending money to that building. And all of those people had to figure out how it was they were going to survive the process. So we're going to go through a little bit of a rundown here of that. So hold on. And I think we got somebody waiting there, Ashley, if you want to figure out. Okay, here we go. So the normal legal disclaimers, you don't have to read all that, but basically we're not giving legal advice unless all you people want to send me a big fat check, and then I'll sit here all day long and we can talk about that. But we want to make sure there's no attorney-client privilege. But we are happy to help anybody who's having any issues in this area. Here are our 4 attorneys. You may have worked with some of our folks. They're all very well versed in commercial matters, including commercial leasing, real estate, corporate, oil and gas, etc. So I wanted you to see the shining attorney faces of our firm. What we do as a law firm, we do real estate, business law, oil and gas, energy, estate planning, elder law, probate, commercial litigation, employment law, and business mediation. But we're going to talk mostly today about commercial real estate and landlord-tenant relationships. Ashley already gave you my background, so I'll skip over that slide. So here's an outline of the presentation we're going to go through today. We're going to talk about commercial leasing 101 because it's important to understand how that process works, especially in the times of COVID. How you negotiate a new lease under a situation of COVID, renegotiating existing leases, which we're doing a lot of, and then some of the other considerations that go into working in the world that we're in right now. And then we'll have time for questions and answers. So commercial leases during COVID, kind of 101. A commercial lease, as I kind of mentioned earlier, you think it's just a landlord and a tenant. Well, there are lots of moving parts on any commercial lease because there's usually a significant investment in a business. So you've got a landlord, a tenant, the obvious parties. You generally have property managers as well if you're in a commercial situation. You may have guarantors, and that means people who are standing behind that lease in case that business isn't able to meet their obligations. Those can be individuals, they can be parent companies, they can be related companies, lots of options there. Generally, there's a lender, and sometimes there's a lender for the tenant, sometimes there's a lender for the landlord, and those folks have a vested interest as well in making sure things are working. Behind the landlord and the tenant, there may also be investors and partners, which further complicates the situation. Also, in certain instances, like restaurants or lots of different businesses, you may have a franchisor or a franchisee, like if this is a Chick-fil-A, or you can name a number of franchises there are out there. There may be a relationship also with the franchisor and franchisee. Real estate brokers in most cases, and then also legal counsel. So you have all these people involved, and whenever there is any imbalance of parties, which may happen with COVID, all of these moving parts become very, very important. So what are the provisions in most leases? It's important to know what these major provisions are, because these are the things that have to be looked at when there are problems. The obvious things: premises, the space and the condition of the premises. The term of the lease can be, as short as month to month, all the way to 10, 15, sometimes 30-year leases. What the use and operations are, and this has become very important. Most leases will tell you that you're permitted to use a lease for a particular purpose, whether it be office, restaurant, retail, and what the exclusives for that may be within that space or within the area. Those all become very critical when you have a problem like we're having with COVID. Securities and guarantees. In other words, there may be a deposit, you may have guarantees, or a combination of those. Rent, of course, is always the big one. What are you paying in base rent? And then what other additional expenses may you have as a landlord-tenant situation? What are the landlord services? In other words, what services are going to be provided by that landlord in exchange for your paying of the rent? And those can be very significantly based on the building you're in, the area you're in, the type of business you're in. Also, repairs and maintenance to the facility, whether the tenant has obligations, the landlord has obligations, or usually a mix of the two. And then if there are any alterations or improvements at the beginning of the lease, or that need to happen later on during the lease renewal or occupancy. And then lots of other more complicated things like renewal options and renewal expansion options, early termination options, options to purchase the property. There's all those things that factor into commercial leasing. It can be very complicated, and that's why usually you want to have legal counsel involved. So what are the key legal provisions when we're talking about COVID? So think about the situation. We all, in the middle of March, have a situation put on us where, in some cases, businesses that were at 100% capacity the day before are now at 0% capacity. And so also, maybe there are restrictions on certain businesses where there are not restrictions on others. Bars were shut down, restaurants went some to 25%, then to 50%, then to 75%, then back to 25%. And those sorts of things have all sorts of ramifications to the lease situation. Also, landlords generally, if they don't own the building outright, they have mortgages that they have to pay. So instantly they're not getting rent. How is it they're going to pay their taxes? How are they going to pay their insurance? How are they going to pay their mortgage? So here are the key provisions that we've seen get invoked during a COVID situation. Timelines, of course, and that has to do with when rent increases. Anything under the lease that associated with build out, if you happen to be in the beginning of your lease, acceptance of the premises, those sorts of items. The absolute obligation of rent, and this is very common in commercial leases, that it says we don't really care whether you have an event outside your control, you still need to write us a check. Interest and late fees, because there are almost in all leases interest on money that's due, as well as usually an administrative fee if you don't pay on time. And how do those get invoked during a time of COVID? Service interruptions. In other words, the landlord says, I really don't have people to come in and clean because my staff isn't able to come to work, or the opposite, cleaning needs to be at a higher level So who's going to provide those higher level cleanings related to COVID? The situation of peaceful enjoyment, almost every lease has a provision which says, I as tenant have the right to peaceful enjoyment of my premises. But if there is an outside force that's saying you can't be open, who's going to enforce that peaceful enjoyment, either against it from the landlord or from the tenant's perspective, the ability to be in that space and occupying it? Condemnation and casualty have come up. In other words, we've made arguments for clients that say, listen, this is just like the government is taking my premises. If I'm a landlord, they're telling me I cannot use it for the purpose that it was intended. And therefore, I'm going to invoke the casualty provision of a lease, which says, or condemnation is government taking, casualty is if there's a fire or a hurricane. These are COVID is very similar to those situations, is what you would argue. Holdover is, in almost all leases, there's a provision that says if you hold over, stay in the space past your lease term, then you pay either double or 150% of the rent. Well, what happens if your lease ends at the time during COVID and you don't know what the future of your business is? And we've been having arguments over those. The default and remedies in many cases in leases, if you default on your lease, the landlord has the ability to lock you out. And we have been fighting lockouts both for landlords and for tenants for the last 3 to 4 months, because landlords want to get paid and tenants want to be open. And so if they're not getting paid, we've been in court on several occasions now in front of a judge saying we've been paying what we think is equitable as a tenant. You need to let us in, and as a landlord, been saying they need to pay rent, and if they're not paying rent, then we have the ability to lock them out. Liens for rent, most leases have a provision in them which says I have a lien on not only the premises, but on the contents of the premises in exchange for rent. So you can imagine the disputes we've had with people who have offices or restaurants full of things that they own as tenants. And the landlord has locked them out and says, I'm taking those things to pay for your rent. Force majeure is the big provision here. Most force majeure premise, and I think most people know what force majeure is, but let me explain what it is. There's a clause in your lease which says if something happens beyond the reasonable control of the parties, i.e. flood, hurricane, labor shortage, anything that basically outside the party's premises, hurricanes, was not anticipated, then we can put this lease on freeze, waiting for that force majeure event to go away. Well, most people didn't have COVID-19 in their force majeure clauses. Most people didn't even have pandemics. Most people didn't have disease or other communicable diseases, unless, which is interesting, believe it or not, these clauses did have those in a lot of gym, like a Gold's Gym or a Villa Sport. Some of those, actually, those leases had them in them because they knew that if there was widespread flu, that there could be an issue associated with their ability to stay open and stay open effectively. So force majeure clauses have come into play, but they aren't really very specific to this particular situation. So what do? You argue in a court of law whether this is a force majeure event or not, and whether in fact that freezes rent. And then of course, attorney's fees. And that is the thing, just when people are shut down, are not making money, the first thing they want to do is write a big check to an attorney. And so that is one of the things that we are fighting. Hey, we're having to go to court. Who's going to pay the attorney's fees? And most leases have a provision which says if you have to sue and you prevail, the other party pays attorney's fees, which is obviously a big hammer. So in this world of COVID, let's say, and we are seeing this, that you need to acquire new space. You're looking for opportunities now in a COVID-friendly business, which there are out there. Medical, for the most part, has done fairly well. Also, any business associated with the reaction to COVID has done very well. Restaurants, hospitality, hotels, entertainment, those businesses have struggled. So we are already seeing a revamping of leases. So the typical process is you have an offering, you basically start looking around for a place to be, and really that is a real intersection of business and legal concerns. Most people, when they're looking at lease space, don't think too much about the legal side of things, and in today's world it's almost critical. Then you go to letter of intent. Once you say, okay, I like this space, I think it'll work, then you want to focus on key issues in a letter of intent, which says, here's the rental rate, here's the square footage, here's how we're going to build this place out, here's the term of the lease, those sorts of things. And in letter of intent stage, you want to try to avoid surprises early on so that when you get the lease, you don't see provisions that are not typical. And then, of course, the lease. And lease negotiations, typically, there's a landlord-friendly form. In most cases, the landlord is the person with the most negotiating power, not always, but often. And often those leases are one-sided to start and are very landlord-friendly. And the point here I would make with regard to the lease is that the biggest mistake we see happen, especially on tenant side of commercial leases, is that you have to be able to focus on all the potential issues that may come down the road up front and commit the time and resources to getting it right. And that doesn't necessarily mean that you spend a lot of time on attorney's fees, but making sure you understand that lease and that the lease has all the provisions that you need to have in it. And this is becoming very, very critical in COVID-related times, because if you have a lease that's already onerous, that you're already struggling to meet, you can imagine what happens once a third-party force like COVID is put into place. So one thing we always like to say is people say, well, I have a real estate broker who is handling this. I really don't need an attorney. Why would I need an attorney? And we work with brokers all the time. And I would tell you, there's a lot of very, very good commercial real estate brokers. I would start with that and say, never go into a commercial lease situation with a residential real estate broker unless they are very, very experienced and have experience in both areas. I'll tell you that is because the dynamics are completely different. You really need to be able to understand all the things we've talked about earlier of how commercial real estate matters are handled. So what's the difference between, or what do brokers versus legal counsel provide you as far as differences in approach? Well, a broker is going to be business term focused. So when you're in the letter of intent stage or you're looking around for space, brokers are excellent. You don't want an attorney involved in that. They're going to focus on business terms. They're going to focus on things like location and parking and the things that are business related. And generally, they also have relationships with landlords and listing brokers. They're generally, real estate brokers, we say good guy or girl, as a guy is the generic term of that. They generally have good relationships, and that's important when you're trying to put together a business deal. But then at some point, we always suggest that you ought to at least have legal counsel involved to focus on legal terms. We don't ignore business side of things, but we're focusing on things that we've talked about earlier. We're experienced in the market, potentially landlord. We've been doing this for, as you mentioned earlier, for over 25 years here in this market. And we also know a lot about various landlords, properties, et cetera, because we do deals all over. And then generally, we're going to be the bad guy. I will just tell you that. We're the person that's going to be your advocate. And we don't really care if we make a landlord or a tenant mad, because it's our job to make sure you're protected. So what are the leverage points when you're negotiating a lease? Well, term, shorter terms give you more flexibility. There's an inverse relationship to rental rates. If you know you're going to be in business, you like the location, longer term will usually get you better rates. Security and guarantees from a legal perspective, if you're a tenant, less is best. If you're a landlord, you want some sort of security in case that entity can't live up to its obligations. If they're required, we always push for burn-offs. In other words, they go away after you've performed a certain period of time, burn downs, which means that they at least reduce over time, and some limitation and caps on securities and guarantees. Additional rent, we haven't talked too much about this, but most retail type leases have some sort of additional rent, as in either just what they call CAM, which is common area maintenance, where they have to blow off the sidewalks around. They need to provide landscaping. They need to provide security in certain instances. There are also sometimes some what we call profits interests, or they call it proportionate rent, where the landlord at some point wants to share in the upside because they're putting you in a shopping center or some environment that they feel like if they do really well, we both do well, and they will share in some of the upside. On CAM, we want to make sure there's increased caps. You don't want them to just be able to unilaterally increase the cost associated with the building, because in many instances, the common area expenses, including taxes and insurance, can be 25% of what you pay in rent. And so you want to make sure that you have some limitations on exclusions and caps. And then service interruptions have become also very important, associated with leverage points. And that is making sure that you can stay open, that the landlord's going to be there for you and the services they're providing, and vice versa, that tenants stay open, because there are provisions in leases that say if you're not open, then that is a default under the lease. So more leverage points, default, and remedies. You want longer notice and cure periods if you're a tenant, because that has become critical in COVID times, because you can imagine what it's taking for people to understand how they're going to cure rent. And then from a landlord perspective, you want accelerated rent. If in fact you don't pay, then they can accelerate the entirety of the lease, which provides leverage. From a tenant's perspective, you would rather not have that remedy. Lien for rent we talked about, and then force majeure, as we said, COVID pandemic specific terms are now going to be the vogue, by the way. They're going to be in leases, and some termination options if these things happen. So. All right, how do we renegotiate existing leases? We're doing a lot of this, by the way. Is what's happening is, especially restaurants, the new normal, although I hate that term, it's just frankly what people are talking about is that people are having to in restaurant business look for more outside space, because people want to be more comfortable. So we're seeing negotiation of chairs and tables outside if they can do it, building out of outside areas because there aren't restrictions on those. We're also seeing what our restaurant clients are telling us is that they believe for 2021 that is a likelihood that they are going to just see about 80% of the business that they were seeing in pre-COVID times, which means that has to flow somehow down through the economic model to the landlord and potentially to their mortgage companies. So pre-default, if you're renegotiating a lease, which is obviously a better position to be in than post-default, landlords appreciate direct, transparent communication. So what we've seen is effective is for people who are in a situation where they're having troubles paying rent, just to sit down and say, here is the reality I'm dealing with now. Here's the reality it looks like I'm going to be dealing with later. What sort of breaks can you give me associated with either past rent, if you haven't paid all your rent up, or current rent, and possibly rent reductions over the period of the lease. And I say in here, be careful not to show your full hand in these negotiations, but you have to be open and honest. More options are available with good faith dealing. In other words, if you are dealing in good faith and you're a good tenant, landlords will want to work with you. And on the landlord side, landlords want to work with good tenants. The alternative is to default you, lock you out, and then what's the landlord's remedy at that point? Try to collect money from a business that's no longer in business, and by the way, re-let the space, which is not a great thing to be trying to do right now, especially in the restaurant, hotel area. More options are available because the threat of default is out there. The landlord doesn't really want default, obviously. And potential less options if fire isn't lit yet. In other words, there might be less options if the landlord thinks, well, they're just trying to renegotiate. Now, what happens if you're post-default? It depends on the sophistication of the landlord, frankly, and the size of the center and what all they're dealing with, or center or building. Basically, you also want to make sure the landlord has performed if you are in default. And this is, as I said, we're spending a lot of time on this issue of, did the landlord fully perform during COVID? because it isn't just a one-way street. Legally, leverage is somewhat lost because they do have the right, in most cases, to lock you out. They do have the right to accelerate rent. They do have the right to charge late fees and all these other things. And then you have to be able to, if it is truly a situation where it is a going out of business or staying in business situation, you need to be able to stand your ground and say, this is the only way I'm going to remain in business. All right, what are the legal arguments specifically? And I'll tell you a little story just to light the color. We had a restaurant call us, a restaurant here in the Woodlands owned by a very large restaurant company, where I got a call about a month ago on a Friday at 3 o'clock where they said, I just got locked out and I want you to go get my restaurant open by 6 o'clock because we have reservations. And so we got busy. Ran down to the courthouse and basically were able to get the judge, based on equitable arguments, saying there's 21 people sitting outside this restaurant who aren't going to have jobs tonight and probably won't ever have jobs again because this restaurant will close. The landlord hasn't fully performed. And these are the things that we argued. Force majeure, of course. It didn't include particular reference to pandemics, but we said this is obviously a situation outside the control or the anticipation of these parties. We need to freeze the situation. Often those force majeure clauses will exclude the payment of rent. They may say, if anything like this happens, you can freeze this. The only thing you can't freeze is that rent check coming to me every month. And so in this particular case, we fought over that. Equitable arguments, frustration of purpose. The whole purpose we rented this space was for a restaurant. We can't open a restaurant here, or we can only open half a restaurant. Impossibility, impracticability. These are equitable legal arguments saying it is impossible for me to run a restaurant at 50% capacity. It's impractical for me to do that because I still have to have a chef, but I'm only cooking half the food. I still have to have wait staff, but I can't have half the wait staff because I have to be able to open the place. Hotels, same thing. I have to be able to provide maid service, but I only have 3 people in my hotel. So how do I live up to this situation? I'm sorry, let me go back here. State by state review is required if you're in other states, but generally these points are equitable. In other words, you're asking the judge just for equity, for the sake of what is fair. We need these remedies. Breach of quiet enjoyment we talked about. You have to be able to quietly enjoy, and then we talked about casualty condemnation. Those are arguments that we've made. What are the leverage points that you want to talk about? Rent deferment is the thing that basically what you want to do is you want to say, all I want is for you to not make me pay for a restaurant that I can't have open, or don't make me pay the full rent for a restaurant I can only have half open, or a hotel I can only have half open, or a Flips gym. You can name all the things that are having to operate in reduced capacity. And the landlord, frankly, most landlords, if they want that tenant, are working with tenants to figure out how to spread that rent over the remaining term of the lease. Rent abatement. Abatement is basically saying free rent in exchange for either future months or just free rents. And we are seeing this where landlords are saying, okay, we'll give you 3 months free. We'll give you May, June, July free, but we're starting in August back where we were. That can simply kick the can down the road. In other words, if you tack it on to the end of the lease, then you sure hope that things are better when you get towards the end of the lease. And basically, all landlords are not willing to work on this basis, depending on the attractiveness of the lease and or the area and whether they would do that. Rent reductions is we're also looking at that. In other words, let's just restructure the whole lease. We got 5 years left. Let's sit down. Let's figure out what rent makes sense. And go from there. They are less likely to do that, but it is something we're seeing if it is a favorable tenant. Other things, percentage rent. I talked about that. Percentage rent is saying, okay, we all don't know what's going to happen in 2021 with COVID. Why don't we put in place a situation where I pay a lower rent, but if things get better, I'll share some of the upside with you. Combinations and trades. You know, landlords, everybody's getting creative on how can we get together and maybe trade off space, put you in this space, move somebody else into your space to try to keep the buildings and the space occupied. Basically extra deposits, new guarantees in exchange for reducing rent. And can we swap out tenant benefits? You know, unused allowances, future abatements, and all things that are already in the lease, can we swap those out for current relief? Financials become critical. While under most leases, you probably have an obligation to provide financials maybe once a year. It's now becoming where you got to be prepared to provide your financials now and sit down with the landlord and really talk about where your business is. Other considerations. There are some, and we've all heard about the PPP loans and everything else, but there are some considerations outside the landlord-tenant situation that you got to look at if you're in that situation. One being insurance. Some people do have business interruption insurance that covers pandemics. Not all of them do, but some do. Or casualty policies could be invoked if you have potential specific release related to the pandemic. Unlikely source, but everybody needs to look at that. And there has been some legislative discussions about basically statutorily requiring business interruption policies to pay in these situations, because no one anticipated this, but it is the ultimate business interruption if you think about it. Check for bacteria, virus endorsements. Riders, as I mentioned, gyms a lot of time have bacteria, virus endorsements on their policies, and other things. So you definitely want to talk with your insurance broker if you're suffering a loss. Government intervention and relief. This has all been all over the news. Is there going to be a new relief package? We all know about the stimulus plans and the PPP loans and all the SBA loan packages, and many people took advantage of those. Now we're sitting in a situation where, are those loans going to be forgiven? We believe for the most part they will be. Will the proceeds be taxable? People don't really know. And will there be a second round to keep businesses going? And I will tell you what we're seeing in our business is that the PPP loans stood people up for a while. In other words, we're able to keep them going. But there are many businesses now that money is gone and they're trying to figure out how they're going to survive. There are limitations on evictions, but generally they are associated with residential properties. So if you have an apartment complex, which we have a lot of clients that do, there are some limitations on evictions. And they're more than likely, as we see the national election play out here in the next couple months, there's going to be some direction in how we're going to go with stimulus packages. So just stay tuned on that front. Conclusive remedies. You know, these are some where basically people are saying, you know what, I'm done. I'm either done with this tenant or I'm done with this landlord in this particular property. And we have seen attentional default walkaways where people have a sole purpose business. They've been teetering on the edge anyway. They don't have guarantees. And they just said, you know what, this is just the end of my business. And we're going to go ahead and lock the door, throw the keys inside, tell the landlord, good luck. And that, frankly, is sometimes the best alternative if you are struggling. Once again, you have to make sure there's no security deposits, guarantees, other things that you don't want to materials in the property that you aren't able to just walk away from. Bankruptcy. We're not bankruptcy attorneys, but if there is the possibility that you just are illiquid because of this, because of loans and other things, there are reorganization and other filings that ought to be looked at. And then sublease, assignees, franchisor release, selling the businesses, all of those are looked at. So yeah, we have a ton of subleases going on, by the way, especially in the office building. People who are restructuring their office space and saying, you know what, everybody worked from home for the last 9 months. Do I really need 10,000 square feet? I think I can do with 5. And so they're saying, I'm going to sublease half my space. We're seeing a ton of that. In the Woodlands, it's really starting to put pressure down on office lease rates. Assignment, where basically say, hey, there's types of businesses that are doing really well. We're in one that's not. You know, there's a medical person who wants to open up a medical office here. I'm just going to go ahead and assign my lease to them. Franchisor, if you are a franchisee, franchisor on a franchise, a lot of times the franchisors take this opportunity to take over franchised businesses because they're bigger, deeper pockets, and they can withstand this better than just a small business. And then selling businesses. We are seeing people who are taking the opportunity to say, you know what, I'm done. I've done this for so long. I'm just going to go ahead and sell my business. And we are seeing some action in the selling of businesses. As I said, franchisee, franchisor, there's potential options there as well. So these are all what we call conclusive remedies. In other words, we're going to go ahead and wrap this up, and I'm done, and I'm going to pass this on to someone else, either forcefully or via a deal. Workouts and settlements. If all else fails, but to control the damage, negotiate a workout settlement between the landlord and tenant, you must consider basically all the factors, including everything we've talked about remaining, total damages, any other businesses you have, security guarantees, all those sorts of things. Many landlords are taking cash payments, settlements, basically saying, just pay me, $100,000, I'll let you out of the lease and you can go. I will tell you, legal counsel is highly encouraged in all these negotiations because there are short-term and long-term legal effects of these on both from a personal perspective as well as a business perspective. And if there's no post-default litigation filed, then you are going to need help with constructing the case, either defending a case or pursuing a case, depending on where you are. So, closing this out. Good lease situations start at lease inception. That's why at the beginning we went through leasing 101. People who negotiated good leases, had good provisions, have a good business are generally doing okay through this pandemic, and they're going to survive. Identify practical spaces on reasonable terms, negotiate the best deal you can. Don't ever feel pressured or that you need to get a lease done in a particular time, because that's where we see people sign bad deals. When times are good, be a good tenant. This is the practical side of this whole thing. What we're seeing is tenants that were good tenants, landlords are working with them. Tenants that were bad tenants, this is the opportunity to go ahead and get rid of that bad tenant. And so that is the old, no good deed goes unpunished. Those people, and vice versa, by the way, landlords that are good landlords, people want to stay in that space and they want to work with that landlord. So pay your rent on time. Don't make unnecessary complaints, demands. When the times are good, be generally polite, professional, open, honest, treat those landlords well. And now when it's coming back, they're going to treat you well. If operational headwinds like COVID hit, start dialogue ahead of the default. Start talking with your landlord and saying, you know what, COVID shut, I'm 95% capacity. Just so you know, that's how it's going to be. And I'm only going to be able to do 95% of the business I had this month. I'm not going to be able to pay rent. And can we work this out? No de facto default unless you admit or give reason to believe you are actually in default. In other words, it's not de facto default to tell the landlord, here's the reality of the situation. If you say, listen, I'm done, I'm out, I'm defaulting on my lease, then they may have a legal action to take against you. Avoid surprises. Renegotiations and workouts are a gamble. They really are. 2021 is uncertain on many fronts, including COVID. And so you do have to go into any renegotiation knowing that these are not certain times. But if you have a good business and you understand your market, understand where you're going, you can control those things that you have the ability to control. Okay, any questions? I got through that in about 40 minutes. Got some time for some questions. And I haven't been watching the chat. Maybe you have, Ashley, if there are any in the chat.
Yeah. I have. If anybody does have any more other questions, please put them in there if you need any clarification on anything that Bret covered. At this point, we don't have any questions.
Perfect. Well, it must have been amazing. That's all I can say is I'm sure it's an amazing talk. No, it is a very complicated topic, but when I reached out to Ashley on this topic, I'm just telling you that myself and many business attorneys in the area, well, all over the country, but I will tell you in the area are dealing with these situations every day, and it is a very, I would say, topical topic for chambers of commerce, because I know what is happening in Conroe and in the Woodlands as far as chambers of commerce go. And those businesses that are in those areas hard hit by COVID are struggling with every dollar. And
Absolutely.
rent is one of them. And you go on down the list, and you know, how to be involved in the chamber is another. And so we want to be there for our businesses, and I know the chamber does as well. So these sorts of talks and seminars are very important.
Absolutely. We do have a question from
Yeah.
Robertson. Bret, are you seeing courts and juries agreeing across the board that force majeure clauses cover pandemics such as COVID-19?
Let me tell you what I'm seeing. First of all, getting to a jury right now is almost impossible because of COVID. So there's not to get too much into what's happening in the courts, but just say this is that the jury trials, you are a lot of times having to agree to a smaller jury because they don't want to have 12 jurors. They want you to agree to 6. Jury trials for the most part have been pushed, very limited. Some courts are having jury trials, some aren't. And I will tell you, most of these landlord-tenant disputes end up in front of a judge. So let's start with that. I think if you get in front of a jury, you'd have a lot more success. We haven't been able to get in front of juries yet. But as far as judges, yes, we've had some success, especially if success for tenants, because if the landlord is being egregious and is not being flexible, in other words, just the first month, if we had people lock people out in May, you can imagine how a judge felt about that. Nobody knew what was going to happen. There were shutdowns completely especially in the restaurant business. So yes, we've had success. Now I will tell you, as time has gone on and as things have reopened and as things have become a little more clear, the success rate for tenants has gone down and the success rate for landlords has gone up. And I will tell you that because in the end, what the judges look at is they say, has the landlord been fair? In other words, have they cut you some breaks on rent? Well, yeah, they have, but I still can't pay. Well, you got to pay rent. At some point, you really have to pay rent. So you got to either figure that out or just go ahead and we're going to fix the situation. But I will tell you, there's some real equitable arguments that have been very successful, and that is this. Like the one I mentioned, 21 waiters, 5 cooking staff, 3 or 4 general managers, 40 people out of work immediately as soon as the doors are locked. And those people are going nowhere, by the way, but on the unemployment rolls. And so there is some arguments where judges are saying, I may not award a remedy to the landlord right now, but my suggestion is you guys go in the back room and you figure out how it is that you're going to settle this, and you're going to pay some rent, and you're going to open those doors because we need people who are working and having and able to earn a living for their families. So I know it's a long question, but it is that complicated on a case-by-case basis.
Has there ever been any other time in your career that you've seen such a broad and widespread evoking of force majeure clauses by parties to a lease?
Only in Katrina, I would say, and some of the Ike and some of the other hurricanes, but not on this widespread basis. Not nationwide. We do work all over the country, not nationwide like this, and I will tell you, force majeure, because the clauses generally don't directly address this, has been tough. Impossibility, saying it's impossible. How you want me to pay rent, open a restaurant? You know what? They're telling me I'm going to go to jail. In certain jurisdictions, they're telling you you're going to go to jail if you open a restaurant. Impracticability, in other words, how I opened this thing for a restaurant and I can't even open it as a restaurant. Those arguments have been better. But no, I've never seen this widespread of discourse with what we call equitable arguments in my career. And I've been doing this a long time.
All right, that is all we have in the chat. And I want to be mindful of everybody's time too.
Sure.
Thank you, everybody that joined us today. I
appreciate it. Thank you, everybody, for tuning in early in the morning. It really is a pleasure to support the Conroe Chamber, Ashley, and all you do in the community. for those that are on and those that maybe listen to this, support your chambers. They really do need to be there for you. You have to be there for them. And if you're doing well, you're in one of those businesses where you're selling PPE and you're selling masks, or you're seeing people and you're making a little bit of money, sponsor their events, renew your membership, and do what you need to do, because there's some out there that just can't do it. So thank you, Ashley, for all you do.
Absolutely. We definitely appreciate it. If you guys have any other questions, we're going to put this up on our YouTube channel as soon as I can today. And so if you know anybody that might want to watch this or may have missed it, then they can watch it secondhand through our YouTube channel. Of course, be following us on all of our social media platforms, Twitter, Facebook, Instagram, LinkedIn, Pinterest, and YouTube. And of course, if you have any questions, you can always shoot me an email.
Yeah, or give me a call. Y'all should have my contact information. I'm easy to find, strongfirm.com, and feel free to give me a shout. Be glad to help anybody who needs any help.
Absolutely. So Bret, if you can make me the host again.
I will do that. Stop
Meeting.
sharing.